by Honorable Nandala Mafabi and the other gentleman, I don't know whether to see me, the other one who should see me, yes, I think so. And the House decided on that. The question was, if this is the decision of the House, where is it in the Act, in the amending Act? It's nowhere. So the question really for resolution, you can persuade me that I'm wrong. The question for resolution, first and foremost, whether the Act as it came reflects the decision of Parliament. Because a clerical officer, the Parliamentary Council cannot alter the decision of Parliament. You are a legal officer. When a judge or magistrate decides and issues a decree or an order, when you are extracting that order, if you change the meaning of that order, it will be cancelled. You know this. Now, lift that and paste it on a resolution of Parliament. The same rules ought to apply.
My Lord, this issue is an issue of both law and fact. The law, my lords, we have taken you to the paragraph at 562 by Nandala Mafabi.
Yes.
We have shown you the clause that he was referring to, and it is clause 1051. My lords, if you're not convinced by our arguments, you will make a finding, but that is the argument. And I'm imploring this court to read that record very carefully.
Okay, we will. And
my lords,
we will read it over and over again and see whether you persuaded us.
I'm most obliged, my lord.
Council, you say that if we hold that 260 was amended, it will create an absurdity.
Yes, my lord. The absurdity would be that, in fact, the Amendment Act does not show 260 was amended. And they are not saying it was amended by infection. They are saying it was on the record of the Hansard, and it is clear that it was amended. Now, the clerk was very clear. She said, a question is put and agreed to. The question was put. Unfortunately, the question is not written. The question is not written, my lords. You can go back to those who will see, they will say question put and agreed. Now, my lords, the absurdity would be like this. We are members of this bar. We make submissions. Sound correct?
Just a moment. If you say the question is not clear from the record, the question that was put, is that what you're saying?
I'm saying the question is, you cannot see what question was put. Okay, usually they would say the question is
just a moment.
And agreed.
If it is not clear, then why do you say the question that was put did not amend?
I'm saying it is not clear, is as in it is not framed like an issue, that this is the question and then you'd have the italics and then you read the question. The question comes from the debate. The debate begins at 562.
No, the question does not begin from the
debate. My lords, that is our case.
No, you listen. When court is speaking, you know this, Honorable Ms. Kawa.
Yes. We know it's your case.
But we are the ones to decide, not you.
Please
keep quiet.
You cannot stand there and talk things that don't make sense to us and insist that we accept them. And they don't make sense. They don't make sense to me. Honorable Kutana said that 260 was never amended. That the entrenchment has to go to, can you sit down please? Has to go to 105. Mr. Kutana, can you sit down? The entrenchment has to go to 105. We said no. Look at the record. In fact, it was. Then he called another gentleman, a lawyer from the Parliament, who came and actually misled court that it was a typing error. That this must have been a typing error. Now, you call the clerk of Parliament, she says the question was not put. We show her the record, she says it was put, but because I think it was not put properly, so I drafted the bill according to how I thought it should look. Then the question was put by the Honorable, had you amended the answer? And the answer was no. So for me, as far as I'm concerned, this matter is done. And we know your position. We can proceed to another issue.
My lords, on that point, having scrutinized the record, I want to put the record straight. When you look at page 5263 of the Hansard, 5263? 5263, yes. There is a motion by the Honorable Nanda Ramafabi which says, Madam Chairperson, we have moved both amendments that this article be re-entrenched under Article 260. We entrench it to be under F. We add and 2. The justification is to avoid it being changed at we. And the chairperson says, okay, honorable members, I put the question that the clause be further amended as proposed.
Yes.
And the question was put and agreed to. Now, the import of this is that actually that portion 2 was amended. Having said that, that portion was amended, it's on record. However, being an entrenched provision, it has undergo another step, another process of being subjected to a referendum. The movers could decide to go ahead with that process. They could decide to abandon it.
So what is it, Honorable Attorney General? What should we take as the correct position of the case of the respondent? That there was no amendment according to the acting director, civil litigation, or that there was an amendment according to the Deputy Attorney General?
And 2, according to the answer. Just a moment. Second, if, as you say, which is what we've been saying all along, the records are quite clear that the Nanda Ramafabi amendment was voted by the House, that term limit be restored and it be entrenched in the Constitution under Article 260 as paragraph F. These are the wordings of Nanda Ramafabi. In view of the fact that this decision by the House is not reflected in the amending Act, what do you say?
My lords, it doesn't occasion any harm. It could never be reflected in the amended Act because it is yet to undergo another process. The only provisions that went in the amended Act are those that were completed at that stage. But this very one,
what does the amending Act say with regard to Article 105? What does it say? Nothing at all? Nothing. Restoration. Is it silent on restoration of term limits?
On entrenching term limits?
No, that's not my question. Don't ask your own question.
Restoration is there But the entrenchment is not there.
No. If restoration is there, under which authority?
You see, there are two aspects.
Parliament did not just put the right foot inside, even the left. So how have you dealt with it? Does the amending act state that this one is to be restored subject to a referendum?
No, there are two steps, my lords.
Yes.
There is amending Article 105 by putting there term limits. That was done, and it is in the act. But to say that the term limits should be entrenched is yet another step, which has not yet been accomplished.
No, actually, it's what you are complaining in Parliament. That is, you people, what you are doing is unconstitutional. You're on record. What you have just done, let me read for you what
we hope it's the same Rukutana who is the Attorney General of Uganda. It's recorded as having been a voice of reason.
Madam Chairperson, I want to move well aware of exactly what we have just passed. The motion by Honorable Nandara Mafabi, if I heard him very well, is to set some limits. We have not had the occasion to debate that motion. We would have demonstrated that some reasons we have used the same reason and the same reason. Secondly, the matter cannot be amended by this Parliament. It's a question of referendum. And this was by you, Honorable Festival.
My Lord.
And after that, they rubbished your...
You were swallowed up in the den of Parliament.
There were interjections.
My Lord, I want to invite you.
And the chairperson said, the issue which went to the referendum in 2005 was the issue of political system.
I want us to appreciate the process. And we can only do so.
The chairperson says, no, we need to vote on it already, and then they vote it. So the question my Lord put to you, or put to the land director of the land director of civil litigation, was that if this court made a judgment, then the court of law and the registrar or council is to reduce it to extract a decree from that judgment. Does he have any power to leave out any decision of court, any positive order of court in that judgment? It was just comparing and said it is also so in this case, because the final motion that was put to vote by Honorable Raphael Marquez includes the amendment. And I don't see why we should, for me I say I'm very tired, I don't see why we should go back to this again, which we exhaustively dealt with yesterday. Because the final motion which said report from the committee, this is the, to me, this is what is equivalent to the decree. I beg to report that the committee of the whole house has considered the bill entitled, what? The Constitutional Amendment number 2 Bill of 2017, and passed the entire bill with amendments. Now that's one. And also introduced again and passed new clauses amending Articles 77, 181, 29, 291, 105, and 260. I beg more. This, in my view, should have been reflected in the bill.
My lords, I entirely agree with the correctness of that record. However, as I said, that is the process. An act is not passed until it has gone all the way to being assented to by the president. My submission, my lords, is that for that portion under Article 260 that needed a referendum, the process is still ongoing. Yes, it was passed,
Honorable Rukutana,
when you read...
Honorable Rukutana, please. You see, we're going to meander for nothing. The question is simple. Is it left to an administrative process, or should it have been... I remember when we were in the Constituent Assembly with lead counsel on the other side, Ontaro Gallo, we were very clear. It was inserted, you were there, on the issue of determining the end of referendum, or the end of movement system governance, and moving on to open competition. It was inserted that it would be determined by a referendum. You recall this. It is still somewhere in some constitutions. And this was done, I think, in 2000 or something like this. So my question is, I follow your line of argument. It is pretty. It is quite pretty. But my question is, if it is not reflected in the amending act, under what authority would you now say it is pending, something which you can shelve, because it is not in any law? And yet Parliament made a decision which should be contained in the amending act. Shouldn't the amending act not have stated that article subject to referendum, this article is amended, God, blah, 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 blah. Then you know that it is an incoherent process, meaning it is a process in motion. It's not yet complete, like we did for the Constitution in 1995.
My Lord,
yes.
To appreciate the process, I invite my Lords to read Article 260. It says, a bill for an act of Parliament seeking to amend any of the following provisions specified in Clause 2 of this article shall not be taken as passed. Unless it is supported by on the second and third readings by not less than 2/3 of all members of Parliament, and B, it has been referred to a decision of the people and approved by referendum. My submission is, at that stage, those provisions which could be passed without going for a referendum would be passed. However, Parliament having expressed themselves on the bill, the portion that has to go for a referendum can be severed and subjected to a referendum on its own
by an administrative process. Once it is lifted away from the law, then you can only do it now under an administrative process.
Because, my Lords,
even if just a moment, this was not an ordinary parliamentary resolution where you can increase the number of judges from 50 to 82. It's just a resolution. This is in a bill, which upon the presidential assent, it becomes law. It's an act of Parliament. So what is wrong in that bill stating clearly that a referendum shall be held on the issue of whether Article 260 should be amended on these terms? What's wrong in that?
And I think
that cannot be stated in a bill.
My Lord,
why? We did it in the Constitution.
My Lord, I think Honorable Rukutana is aware, is a very, very senior lawyer, the Deputy Attorney General, that we have switch state, for example, that sections 1, 3, and 4 shall not come into force until ABC has happened. It can be stated. So it could be have been, what you are saying is correct, but it ought to have been stated by Parliament in the hands that Articles 105 and 106 we have debated, we have agreed, but they are not going to be in this field until the referendum is held. And if that had been stated, then the bill would be drafted without those articles, or with those articles, but still with that statement. Because it has been done in many laws. this will await this, will await that. And that's all. Secondly, you run into problems because remember, you are replying to the submissions of counsel for the respondent, for the petitioner. Now, the petitioner's argument was that we should declare this act unconstitutional because, one, directly or by implication, Article 260 was amended. And having amended Article 260, then the requirements for passing the bill had to be made, including a referendum, including the certificate of the Speaker and the Electoral Commission, including the separation of sittings. So it does not actually stop there. It also goes further that the certificate of compliance would now, in a private member's bill, because there is the issue of referendum, would require money from the consolidated fund, and as such, under Article 93, it would not pass the test as a private member's bill. So it is not just this a way and the chain of arguments along and around this.
That was Honorable Attorney General. That was precisely what you were trying to guide Parliament to do before you were drowned out. You were trying to tell them, but look, what we've done will run into problems. If I read your mind from the records properly, because of the need for a referendum to amend 260. But of course, you were a lone voice of reason and...
My Lord, I entirely agree with the procedure as stated by my Lord Justice Kakuru. However, that is one way of doing it. One way of doing it is, as my Lord Justice Kakuru said, putting it in the bill and saying it will come into force after the requirements have been fulfilled. But another way is severing and getting those provisions that don't require a referendum in one bill and separating this to be treated separately in a manner that is required by the law. And that is our submission.
Yes.
Okay. President Kawa, can you go ahead with your submission? We'll put our reasoning in our judgment.
I'm most obliged, my Lord. Just to conclude on that issues, my Lord, I refer you to page 262 of the Hansard at the bottom. 262? 262. Rather 5262.
Okay, 5262. Okay.
At the bottom, the chairperson there states, honorable members, I put the question that Article 105 be amended as proposed. At the top of the next page, 5263, the question is put and agreed to. Now, what seems to bring the problem or the uncertainty and grey area for us here in this court is that immediately thereafter, Honorable Nandala Mafabi again moves the chairperson and says he wants that article re-entrenched and then introduces Article 260. The chairperson says, okay, honorable members, I put that clause be further amended and proposed. He's talking about that clause being 105 and not 260.
No.
I buttress that submission.
The chairperson is talking about re-entrenching.
No, she says that clause. That clause appears to be the clause of 105(1). Now, my lords, that question.
That's your version, Council.
I'm presenting my response.
Is not the version of the Hansard.
It is the version of the Hansard. I'm referring it to the Hansard, my lords. And that is the explanation that I'm tendering. So, thereafter, at the bottom of that Hansard, still in that corner, at the bottom of that Hansard, in the right-hand corner, Okupa, Mr. Okupa, Honorable, states this after Mr. Rukutana has submitted. He says, Madam Chairperson, the Attorney General should be courteous. You had ruled on this matter. Is it order to proceed that way? The Chairperson says, no, we voted on it already. What was the vote? The vote was, and my submission is, it was Article 1051, not 260. That is the respondent's case.
Okay. We have heard you loud and clear.
Most obliged, my lords. My lords, that begs the question then, should there be a 14-day gap in between the sitting of Parliament? The question would be no, it is not required because Article 260 was not entrenched. I then go to submission, the next submission on issue 11, my lords. Issue 11 is whether Section 9 of the Act, which seeks to harmonize 7-year term of Parliament with the presidential term, is inconsistent with and or in contravention with Articles 1051 and 262 of the Constitution. Now this issue concerns Section 9 of the Constitutional Amendment Act of 2018, my lords. Section 9 is under Part 4 of that Act, and Part 4 is amendment of Chapter 19 of the Constitution and is referred to as transitional provision. That Section 9, and I will read it for clarity, it provides that there is inserted immediately after Article 289 the following new article. The following new article is 29A, capital A, and it is application of Clause 2 of Article 105. It provides, my lords, the amendment is that Clause 2 of Article 105 shall come into effect upon dissolution of the Parliament in existence at the commencement of this Act. That, in a way, answers what Honorable Justice Fakulu was asking from the Attorney General about how the laws are made. So the transition is right here in the Amendment Act. My lords, the use of a transitional provision is well known by this court. It is to regulate a process that starts before an amendment or enactment of a statute comes into force, and it ends when the amendment or enactment of that statute has come into force. The transitional provision is a common feature in the amendment laws of Uganda, especially where there is an application of a new provision. It is intended, my lords, to address likely possible lacunas in the law that may be created. I will refer you, my lords, to Chapter 19 of the Constitution of the Republic of Uganda. Now, to the amendment of Article 105, that amendment of Article 105(2) was to provide 4 term limits for the tenure of the office of the President. There was need to pronounce, that is Parliament to pronounce itself on how the new amendment would apply to the sitting of the President at the time of the amendment. This amendment, therefore, my lords, provides clarity to the tenure of a sitting President, and that is why this issue comes up now on the alleged harmonization. My lords, clearly, Article 262F I will take you to Article 262F, my lord. Those are the amendments requiring a referendum. 260, clause 2, subclause F. That is chapter 7, and that is Article 1051. That's the one that needs amendments requiring a referendum. My lord, when we go to Section 8 of the Constitutional Amendment Act, we see that Article 289 of the Constitution was replaced. And Section 8 of that Act, my lord, provides for amendment by substitution. Now the new Article 289 reads as follows and provides as follows, that notwithstanding anything in this Constitution, the term of Parliament in existence at the time this article comes into force shall expire after 7 years of its first sitting after the general elections. So, my lords, when we are interpreting this law, we take cognizance of the fact that Article 289 has been replaced completely. My lords, I will also refer you to Articles 61, Clause 2 and Clause 3, which provides for the conduct of the President, of the election of the President and the general election of Parliament and the local government councils to be on the same day. However, my lords, Parliament in its wisdom amended and only aligned the two terms of Parliament and the local government councils. Section 1B of the Amendment Act has, of course, my lords, it has deleted Clause 3, which provides for presidential elections. Now our terms are not aligned anymore. So in the current form, my lords, it is from the submissions that I've made, it is clear that there is no harmonization of the presidential terms with the other terms. I will refer you, my lords, to the affidavit of the Secretary to Cabinet, Mr. John Mitala, who had the opportunity to present him in cross-examination, my lords. Annexed A to his affidavit and the cabinet paper that was presented on 15th January 2008. The import of that cabinet paper is to try to align the term of the President to that of the Parliament and to the local councils. And this, my lords, was done after the Amendment Act. If you see the annexure there too, it also shows that Cabinet intends to bring another bill, not to amend this Constitutional Amendment Act, but to bring a stand-alone bill. So, my lords, that would clearly show you that Section 9 has not in any way harmonized, doesn't seek to harmonize the term of Parliament to that of the President.
Excuse me, Councillor Kawa. Just as a nexus between this issue and the one we disposed of previously, immediately previously.
Yes, my lord.
It was argued by the learned Attorney General that we need to sever the issue of amending Article 105 and then entrenching the amendment 260. And he says the process is beginning. Now, the head of civil service, who is also secretary to cabinet, was here yesterday. in response to the need to have been cross-examined over his affidavit. The document you just referred to, the one which prepares the nation for a referendum to harmonize the presidential and parliamentary elections, does that document also make reference?
I beg your pardon, my lord, I didn't
does
hear
that document, the cabinet document you've just referred to now,
yes,
does it also make provision that the country would hold a referendum not only about harmonizing presidential and parliamentary elections, but also about entrenching the decision of Parliament with regard to 105, also putting it in a referendum to the people, because the learned Attorney General says it is a process. This is an opportunity. Is it contained in that cabinet document?
my lord, the affidavit of John Mitala introduces a cabinet information paper.
Yes.
So the Attorney General, who is the legal advisor of government, read through the bill, the Amendment Act. When he reads through the Amendment Act, so when he reads through that act, he says, look here, this is the import of the Amendment Act. Is it good for this country to hold the elections? Should we go back to the time when the elections were held at the same time? So the information paper presented shows that it would be desirous for government to have...
No. That's not my question. That one I have no problem with. What you stated, I agree.
Yes.
My question is, maybe I should put this question to the Attorney General, who is more interested in whispering. I'm addressing him. Learned Attorney General, I'm addressing you. I'm addressing you, please. I think I'm grilling an innocent party. This cabinet document, the one which we went through with the head of civil service, secretary to cabinet, which cabinet noticed something like this about the need for a referendum to harmonize presidential and parliamentary elections in view of the extension of parliamentary life from 5 to 7. My question is, following from your own submission when you intervened to support the director for litigation, civil litigation, this was an opportunity to give effect to a clear decision of Parliament. Your argument was that, yes, 105 was amended and is reflected in the amending act. But the process for referendum could not be put in the amending act. I'm beginning to be persuaded by you. My question is, this was a clear opportunity to give completion to what Parliament started. Is it contained in that document that there will be need to carry a referendum on 2 issues, harmonizing presidential and parliamentary elections and entrenching term limits in the Constitution, Article 260. Is it contained in that document?
My Lord, it is my submission that the need for a referendum was recognized to be for harmonizing the presidential terms and operationalizing the provisions of the Act.
That's what is in that document.
Yes, my Lord.
Okay. Proceed. Learned Counsel, please proceed.
My Lord, I would like to conclude my submissions by referring you, my Lords, to the affidavit of John Mitala, the Cabinet Information Paper, which presents the position of government on what the roadmap should be. So, my Lords, I pray that you find that you find in favor, in the affirmative on this issue for the respondent.
Thank you so much. Does that complete the first circuit? on submissions that required
My Lords, that completes issue number 8. And 11.
Yes.
Leaves us with issue number 12. And Mr. Oluka is going to submit on issue number 12.
My Lords, my name is Oluka Henry.
Can somebody just the gadget so that council doesn't have to be breaking his back, having to look for where the microphone is. You seem to have catered for less tall people, not anticipating that some people were endowed with height. Mr. Luke, is that okay now?
This is fine, my Lords.
Okay.
My Lords, my name is Oluka Henry, Principal State Attorney, and I will be responding to issue number 12. And my Lords, I beg that I proceed.
You beg that?
I proceed.
Please do.
My Lords, as a beginning premise, we state that Section 3 and Section 7 of the Constitutional Amendment Bill are not inconsistent with Articles 21.3 and Articles 21.5. My Lords, this issue was canvassed in the submissions made by Mr. Mbale and Mr. Biomukama, and that's in Constitutional Petition number 44 of 2017 and Constitutional Petition number 10 of 2017, Prosper Usingi. My Lords, this court is called upon by the petitioner to state and to make a finding that sections 3 and section 7 of the Constitutional Amendment Bill are inconsistent with Articles 21.3 and Articles 25 of the Constitution. What is of concern in relation to the petitioner, my Lords, is the fact that the amendment in relation to age does bring about a situation where discrimination is brought to bear in relation to the amendments. Of particular concern in this instance, my Lords, is the need not to give a different treatment to different individuals in relation to the matter of age.
But we have a majority age. You can't vote.
I beg your pardon, my Lord?
We have a majority age. You can't vote unless you are 18. You can't drive. You can't even have sex.
Until when lawful sex. You can have sex, but you cannot have lawful sex.
Absolutely.
Until you're 18.
So your aspect would mean that now the law of department will just be thrown out of the window, sort of young olds can marry.
Because it is segregative.
My Lord, that's why when you're interpreting the Constitution, your duty in that interpretation is that you create a sense of harmony. So that there is harmony between those different legs of the law.
It is that the rights are not absolute, and discrimination is permitted in the Constitution as long
it is called positive discrimination.
And that restriction on rights as long as it is justifiable in a free and democratic
Society. Absolutely.
It has to pass that test.
Absolutely.
Can you imagine, Mr. Luka, if my old mother, I hope she's resting with the Lord, who never went to school, that if she stood up to speak in Luo, she would magnetize everybody. Can you imagine her being elected to go to Parliament of Uganda because it would be discrimination to say she must be A-level, let everybody, just imagine.
I can imagine that, my lord.
Yes.
But what is the yardstick? The yardstick is what you have set out in the Constitution, in that anybody, what the amendment now does, is that it opens up a space which was previously closed.
Yes,
Yes, and that space.
That is true, but
Yes.
I was responding
Yes.
to your submission that the Constitution would be violated because of discrimination on account of age. First of all, the petitioner said, and it is true, in the article that sets out prohibits discrimination, age is not one of
the factors. Yes.
And even if it were, the section 43 of
Section 3 and 7.
limitations 43
Yes.
to C. Any limitations of the enjoyment of rights and freedoms prescribed by this chapter beyond what is acceptable and demonstrably justifiable in a free and democratic society. And this was clearly discussed and elaborated in the case of Bonyango Bom and Rumenda versus Anthony. What constitutes the by the Supreme Court?
Yes, my lord.
Proceed. Learned Counsel, proceed.
You, Mr. Luka,
Yes, ma'am.
do you have an authority which supports your argument that if you use age positively, it's discriminatory?
You use age.
When you restrict,
When you restrict using age, that's discriminatory. Do you have an authority at all?
and you should know where we are coming from. Our independence leaders,
We're very young.
is it 30 years, 32 years, 20-something, you know how they messed up us up. Getting annoyed over matters which you can sit over Manuel Port and resolve, they will pick up arms, say, you will see me. So these things have got historical backdrop. It was not arrived at random, say, even in criminal law, you are a lawyer. There's the age of reason. Somebody can only be responsible from the age of 12. You know this. So the people in Uganda thought, to carry the responsibility, the whole of Uganda on your shoulders. You can't carry Uganda at the age of 18.
I agree, my lord. You may not be able to carry.
That would be positive discrimination.
I agree, my lord. That positive discrimination may be accepted in instances. But what is this amendment doing? This amendment is opening up a space which had been closed. It is giving the people the right to choose under Article 1(4) how they will be governed. Because the people will have the discretion to look and say, yes, you're below the age of 35. Yes, you're above the age of 75 in relation to your grandmother. But we have the discretion now at this point in time, because that space has been opened up. And we have the ability now to look at you, gauge who you are, what you are selling to us as your mandate, what you're selling us as your agenda, and we will take the decision to choose.
Why? What we knew all those things in 1995.
Yes.
And the people decided they don't want all people, they didn't want young people. What happened?
The Constitution.
what has happened now?
Well, listen to my note.
This is what
The Constitutional Commission
Yes.
by Justice Odochi and also the Constituent Assembly deliberation considered this matter very, very, very thorough before the promulgation of the 1995 Constitution. What has changed between now and then for it to justify what you are now advocating?
We have just turned only one corner. What has changed? We've just turned one corner.
My lords,
Out of 1,000 corners, we just turned one corner since the promulgation. What has changed?
in 1995, and even prior to 1995, we had the constituent delegates who made that constituent assembly. Today, my lords, we have the members of parliament. Members of parliament who are elected under Article 1(4) to represent the mandate as passed on to them by the people. Because the people vote in these people into parliament. Those people go into parliament and carry forward the views of the people. And what has happened now is that the representatives of the people have made the decision that it's important that we lift those legs of discrimination that still existed and accommodate the section of society. Let note, my lords, that today in Uganda, over 70% of the population may be below the age of 70. There may be a very fair percentage also of people who are above the age of 75. So bring on board those who are below 35 and also bring on board that small majority which is above 75 that had been excluded by the Constitution. And this act is being done by the members of parliament who, as a function, have a right to legislate in parliament. And that right is as manifested.
There is an African saying
Yes, my lord.
that a homestead which has no elder or elders and has no children playing on the compound is condemned to a tragedy. Ever heard of such a thing? The importance of elders in society and the importance of people who will continue the line in society. When you don't have those in a homestead, it is catastrophic.
But there was a private member's bill, I don't remember by the name of Parliament, that sought to introduce, there was a motion, I don't know whether it was a motion, to allow a bill to set up an upper chamber, some sort of senate, where retired judges and retired prime ministers and all the people above 75 would probably sit. I think that one would cater for the instead of only one post, then all the people 75 who are very energetic and useful would sit like the House of Lords or the Senate
And review decision of the lower house.
review decisions of Parliament. I think that would, I don't know, but it was not allowed to be debated. I don't know why. That argument would come in very well.
Anyhow, proceed, Mr. Uruka. Proceed.
My lords, I think what is important and what should be recognized is, one, the need to recognize the youthful individuals in society, the need to embrace the middle-aged people, the need to also hold on to the older individuals, the individuals above 75 years of age. The sum of all these people is a reflection of who we are, and who we are is society. So the question is, do we exclude those who are so old? Do we exclude those who are so young? Then, if we were to do that, we find ourselves in a situation where we are discriminating against a select group of society merely on the basis of age. Now, if we were to do that, my lords, wouldn't that be inconsistent with the Constitution? What is important, in our opinion, my lords, is to embrace society as a whole. And in embracing society as a whole, you go back to the bare basis of what the Constitution is about. Everybody. And in going back to everybody that is in the Constitution, you create a sense of harmony. And that harmony is what the Constitution is all about. Now, my lords, this is something that members of Parliament took into account in bringing about the amendment that exists in relation to Section 3 and Section 7 of the Constitution Amendment Act. So, my lords, to go back to my submissions,
there is the hypothesis, and I think someone wrote on that hypothesis. The hypothesis that the problem of African leaders is overstaying informed. Have you read that hypothesis and the analysis?
You are conveniently not ready.
Council, so today in Uganda, the Commonwealth Parliament for the Youth is meeting, and their deliberations is to address the question or the problem of leadership that overstays in power. By removing any age limit, don't we suffer the danger of having individuals being in power perpetually and actually excluding the youth?
My Lord, Mr. Luka, before you answer, let me add mine. One of the tenets of good governance is orderly succession. Removal of this age limit, will it be supporting that idea that succession should be orderly, or it will be negating it?
My lords, in relation to, in answer to Justice Kasule's first question, I think the people at any one point in time have the right to choose who leads them. And that right to choose who leads them is expressed in the provisions of Article 1 of the Constitution on the sovereignty of the people. Because the people at any one point in time shall express their will and consent on who should govern them and how they should be governed through regular, free, and fair elections. Okay.
Yes, but there are other provisions in that constitution before this amendment, which says the right to express this, the right to determine, to choose who should govern you is restricted. Those people must be within the age bracket of A and T. It's there in that constitution, so it's not a free right. For example, the people of Uganda cannot choose the Senegalese to be president of Uganda, you see? Simply because they have the right to choose. So it is within certain parameters.
And that's why those parameters, right now, with this amendment, are being used.
No, sky is the limit now.
The sky
How do we know next time they'll say we can choose Obama since he's now free to be the president of Uganda?
That may not be possible because he's not a Ugandan.
No, he can be Ugandan in a day. Just get the first
and that's why
he can be Ugandan by registration. The Constitution restricts it.
Absolutely.
To citizen by birth. It's a restriction. I know that Mr. Okafuzi Mr. Okafus, you brought a constitutional petition or defiance, and they were saying that certain people with certain orientation were being discriminated against, including prisoners, I don't know, including, you know. So, the issue of qualifications of a president, your argument seems to support the theory that we should have no restrictions. The president should have no qualifications. Anybody can be president at any age, whether you have education or not education, whether you are a discharged bankrupt, whether you are a convicted criminal officer serving 20 years, you can come. Because that one clause of 8 is part of a number. The moment you start lifting them as bills, means you can also lift all any of the others. And that's the issue. If you can lift that one, first would stop Parliament from lifting one which says that if you are a convicted criminal, you can't be elected president.
You open a floodgate.
Just open it and say criminals, non-criminals.
My lords, I think the qualifications that are the subject of debate here are the qualifications on age.
No, they are all qualifications because
I agree. I agree.
The article, it's the article because the arm that we use to remove this is the same arm that we use to remove the other, and the arguments that just set out apply to any of the others.
So, my lords, I stand to be corrected, my lord. But I think what was debated in Parliament and what is
it's
the
your
subject...
argument that there should be no qualification.
I'm not arguing that there should be no qualification.
So what I say?
The standard, the yardstick that we are debating here, my lord, is the yardstick.
I thought I heard the Solicitor General say, was it the Solicitor General or Mr. Richard that we must look at the Constitution as a whole, that when looking at it, now we are not even looking at the whole Constitution, we are just looking at one clause, and you're asking us to look at only a sub-clause of, if you're opening submissions, that we must look at the Constitution as a whole. So the moment you bring here a constitutional petition, all articles are in issue.
I agree, my lord.
Conclude.
Yes,
please.
my lord.
You made your point. We have been following.
Yes, my lord.
Yes.
I agree that when you're interpreting the Constitution for purposes of harmony, for purposes of giving it the spirit that is the living document, which needs to mirror society, all articles have to be considered. However, my lord, as I stand before you now, I am making reference to Articles 21.3 and Article 21.5, and specifically the element of age as canvassed by the petitioners. And in that regard, my lords, I am saying that the premise upon which Sections 3 and Section 7 of the Constitutional Amendment Act were amended do not narrow, do not give a different treatment to different individuals in society. Instead, what they do, they widen the scope, they widen the diaspora of opportunities to people around the element of participation in the presidency and in leadership around district local governments. It opens that area for that varied section of society. So, my lords, in doing that, it does not contradict the Constitution. It is not inconsistent with the Constitution, nor in contravention of it. Instead, it brings more people on board. Now, what is important, my lords, is make note, because we are talking about a Constitution, but we need to make note of other areas in the Constitution. For example, should it be that civil servants at all points in time have to retire at the age of 60? Should it be that, my lords, you have to retire at the age of 60? That should not be the case. You see, should it be open for everybody else?
In office forever.
There are different ages, my lord.
Even when I no longer know the difference between daylight and night. I still sit in judgment.
Mr. Luka,
Yes, my lord.
should we wait until a president dies before we get another president?
You have the right to express your will. And how do you express your will? You will vote. You will gauge that this president is no longer worthy. And you will vote. And in voting, you exercise your right.
Mr. Luka, beginning from LC1 to the presidency, you don't know of cases where you can say, if it was not for this, this one would not have been here. You've never heard of that?
I have.
Yes. So if you do not have limitation to ring fence certain positions, not for one person of course, but certain categories of people, aren't you going to have somebody who is 14 years, but because of those things, being your president tomorrow? And then you get to be ruled through regions, as it were. Those ones you call psychophants or whatever it is.
Unfortunately,
They will be the one now being your leader in the country.
Unfortunately,
Or when the parabolas come down, somebody who's 90 years, a Mugabe of sorts.
The reality, my lords, is that you may have chosen those regions as the electorate.
That's why we have safeguards. You see, in life and in society, the greatest danger to me is myself. I need to restrain myself from myself. That is the biggest danger. So I need a wife, I need children, I need the rules which say, please, left alone. So that even us people, the population of Uganda, left without us making our restrictions for ourselves, we run a danger of destroying our own society. So we put their restrictions. You can't have a society where there are no restrictions. People go naked on the streets, they drive where they want, because it's a free society. I don't think that's the free society envisaged in a democracy. I think in a democracy, a free society is envisaged where the restrictions we talk about are those under the Public Order Management Act, not the ones I'm talking about.
Actually, the 10 Commandments, you've read it several times, I know. Only maybe the first 3 are saying, do this. The rest are restrictions. Thou shalt not, up to the end.
So, my lords, I think what is important in this instance is to take recognition of the will of the people to exercise the right to choose.
If I may, yes. I think we had a referendum. Was it in 2000?
Yes.
What did it say? It was about movement and democracy.
Yes, my lords.
And all the people voted movement.
Not all the people, but
To go multi-party.
yes,
Yes.
to remove movement and have multi-parties.
That's what the referendum said.
Yes.
I thought that the people voted for referendum, but later, but
No, it was in the, my lord, it was in the 1995 Constitution. The decision was made when Cecilia Ogwal's motion was defeated. A very interesting motion. You should read that Hansard, because it tells you who is who. When people make noise about certain things, Cecilia Ogwal moved the motion that we go multi-party. Not just a moment. And that is why in the Constitution it was enshrined that the people shall determine in a referendum within a specific time. That's why in 2000 there was that referendum.
And my Lord, that goes back again to the fact, again in interpretation of the Constitution,
Yes.
that it's a living document, that it reflects the changes in society. And it's that dynamic in that sense. And that dynamism is what is reflected in what keeps on changing around the Constitution. And that is an embodiment of what is set out in the national objectives and principles of state policy. For example, in relation to number 2, which is the democratic principles, it is stated that the state shall be based on democratic principles which empower and encourage the active participation of all citizens at all levels in their own governance. Now, that participation right now is being reflected through the representatives of the people making the decision that let us bring more people on board in relation to the element of leadership. However, in bringing those extra people on board, we are not dropping the parameters of qualification that are set out. But let's embrace more of them.
That is equally discriminative. So why do you leave that one? Why do you think this is discriminative? It must be removed, age. But when it comes to, that's why I gave the example of my own mother.
It is positive discrimination.
Would I say she can come to Parliament even without attending a single day in a formal classroom to determine matters of, will not understand anything about the state and what have you? Anyway, so conclude, Council. I think you made your point. Yes, yes.
To crown the whole argument,
yes.
It all boils down to the sovereignty of the people. These amendments came up after very widespread consultations of the people. The people evaluated the values contained herein.
I thought,
And came up-
Attorney General, sorry, that Mr. Oluka was submitting on the lifting of the age, and that was not an amendment.
The lifting of
Of the age. I think it came in the first magazine draft. The first magazine.
yes, my lord.
And that's when no consultations have been made. 29 million had not.
No, my lord. That was a proposal which was subjected to widespread consultations. And in their wisdom, the people of Uganda
Is that in evidence that there were consultations?
yes, my lords. Majors came up with a proposal. The proposal
That
was
is the
subjected
constitutional
to consultations.
There was the Constitutional Review Commission. There was the Constitutional Commission, the Odoke, Justice Odoke Commission, that necessitating the setting up of a Constituent Assembly where the people of Uganda deliberated through their delegates. Then there's Parliament, and then after that there was the Constitutional Review Commission, the Professor Sempebwa Commission. They didn't touch anything about age because they went to the people.
My lords, what is so true is that we have, at least on the record, we have affidavits of Lokeris, we have affidavits of Margaret Muhanga, Balyeku. The sum of all those affidavits is the indication of the fact that
The people were consulted.
Yes, my lords. Even when you look at the Hansard, the various people, before they come in the process of voting, they will make very short statements and state that I consulted my people, and my people told me I should touch it. I consulted my people, and they said I should not touch it. And why was that said? That because that was the statement
And unfortunately, I cannot be a witness here. I will go there and tell you that in this constituency, one person said, my people have supported. Another person in the same constituency came to Parliament and said, my people are so opposed.
But
and both had gone for consultation.
I agree, my lord. But the simple reality is, those are the people that had been elected under Article 1 on the sovereignty of the people.
I had said that before. It's so difficult to quantify.
Yes, my lord.
Very difficult to quantify because very subjective. My people may meet my wife and children. Yes, say my people say. Because and that's it. They have said. You don't know the number. You don't know what my means. Whether it's my clan. So, but that's why I was earlier had said that maybe we need to look at participation and not just consultation.
So, Council conclude so that we can have health threats and come back.
So my lords, the yardstick and the prayer we make before this spot is that...
Before you make the prayer, Mr. Lucas,
Yes, ma'am.
you said that the amendment is meant to open up space for more people to come in. Is it really so? Is it meant to encourage or
my lord, I can only look at what is in the Hansard, what has been stated by the people's representatives, but all that culminates in the law that we have. And the law that we have, the amendment that has been occasioned to the Constitution, is the fact that it has, where there was a bus carrying only about 50 people, that bus...
maybe that's not a good example. There are people who will never enter that bus. So
yes, there are people who were never entitled to enter that bus. Can now also...
Let's talk of a plane, okay, or a lorry.
Yes.
Or a matatu.
I think it's not about the people, it's about the driver.
My lord,
It's not about the passengers who can drive.
My lord,
some people talk about views and whatnot. So there are instances where you can never jump a queue. So if there is no opportunity created, is the age limit lifting helping people who want to come in that queue? Or
my lord, if you include more, it will definitely be a better thing. You can imagine those who are out of that bus. Yes, it's driven by one individual. But if they were not on board, they now have the opportunity to go back where...
Don't you think the passengers need to be safe and say the qualifications of this driver? So we need to look at them. Like me now with glasses, I can't drive at night.
Mr. Luka, you are saying it is the will of the people that should be reflected, not so.
Yes, ma'am.
And you took out directive principles. But there was a commission of inquiry, Constitutional Review Commission, headed by Professor Sempebo. And one of the terms of reference under F was to review the qualifications and disqualification of members of Parliament and of the President. Now when it went out, collective views and so on and so on, people talked more about term limits and they left alone this issue of age. They said age should remain intact. It was not debated. Now we have come back and said the people have been consulted. Do you think these consultations, which were done in a short while, for a short period, were more than what this review commission had done?
My lords, one fact that we need to acknowledge, that 1995 is over 23 years ago.
No. Sempebo Commission
Yes,
is
it was
recent.
2003.
Yes, sorry, 2003 is about 13 years ago. Between that 13 years and now, there is a whole new set of Ugandans that have come on board. That set of Ugandans has a set of representatives. That set of representatives came up with the report which was placed before Parliament. That report is a reflection of the views.
Which report are you referring to?
There is a report of the Central Committee on Legal and Parliamentary Affairs.
Is it in evidence?
My lords, that's what was consistently put before the House in the Hansard by Honorable Boff. And that was a reflection of different views that were garnered during the process of consultation. That consultation may not have only been by the members of Parliament, but was a consultation including the various people that were written to by that commission and their views represented. How many were they? But representing various groups.
Counted individuals, government departments, lecturers at Makerere, total 43.
I agree, my lords, plus the 414 from the various members of Parliament, by a reflection of the whole of Uganda.
Okay. Just conclude. We fully followed you. Don't think we've not.
Yes. So, my lords, in closing, my prayer is that you find, my lords, that the act of amendment of Articles 102 and Articles 183 of the Constitution was constitutional, does not in any way bring about an element of discrimination as stated under Articles 21(3) and 5 of the Constitution. I pray that you look at and consider the various views, the various aspirations, the various concerns of the people who have now been brought on board. Those people are the people below the age of 35 and the age and above the age of 75, and the people that fall in between there, in that this amendment opens a space that had been closed and now brings more people on board. But not only that, my lords, this court is going to make decisions in relation to matters of age. I pray that this court finds it in its wisdom wise to consider other elements around the matter of age in embracing and bringing more people.
Which are not part of the petition.
My lord, that's why Obita is allowed.
Obita.
That you would make a decision in order to make that out.
It's something that people will think about, my lord. It's something that you can say.
Why don't you bring a petition yourself? Why are we always on the receiving end? You bring a petition.
My lords, I would have to request the
what you're
permission.
saying now.
I would have to request the permission of the Attorney General and the
You become the Attorney General and you bring it up.
So, my lords, those are my humble prayers. And maybe
my lord, before the prayers, I want to sum up the issue by bringing my lords to the attention of Clause 5 of Article 21, and I quote, "Nothing shall be taken to be inconsistent with this article, which is allowed to be done under any provision of this Constitution." The amendments we are talking about are allowed to be done under the Constitution, so they cannot be taken to be inconsistent with any clause of this article.
I think you had also said something similar in your general introductory submission. Something to say, unless the Constitution does something from being amended, it should be amended. It can be amended. You said something like that. This is now for emphasis.
For emphasis' sake, my lords.
Thank you. The only problem is that that argument was used at the Constitutional Court in the Mbale petition. It was accepted by the majority. When the matter went to the Supreme Court, it was rejected.
Your prayers now, Mr. Doctor.
So, my lords, I pray that you interpret this constitution broadly and liberally. I pray that the whole constitution be read as a whole. I also reiterate the position that has been taken by the Attorney General in stating that that there has been no inconsistency by implementing this amendment to the Constitution. I state that this act of amendment is lawful as provided under Articles
We have had all that, just mind up.
that this act is lawful as provided under the articles on the powers of Parliament in making laws. And that being the case, my lords, I pray that you find and do not make any orders towards stating that this act is inconsistent with the Constitution of Amendment. I so pray, my lords.
Thank you so much. Learned Counsel, we will resume court for further submissions at exactly midday. It's about close to 20 minutes time.
Raise the praise. Get inspiration. Rise up every morning with a song of